todos ustedes. Hoy día terminaremos, confío que exitosamente. Ayer ha sido una jornada grata, llena de exposiciones, todas muy versadas, muy interesantes, muy estimulantes y muy innovadoras. Prosiguiendo con el programa, cedo pues al conductor para que podamos arrancar puntualmente y así proseguir a lo largo de todo el día de hoy. Muchas gracias por vuestra presencia.
Good morning, distinguished guests, ladies and gentlemen. It is my great pleasure to welcome you to the second day of this third World Meeting of International Law Societies. Yesterday, we had the privilege of hearing from some of the most brilliant legal minds from around the world as we explored the latest trends and developments in the field of law. Today promises to be another exciting day as we delve deeper into some of the key issues that are shaping the future of international law. As we begin our proceedings, I would like to thank our esteemed keynote speakers, moderators, and panelists for sharing their expertise and experience with us. Over the course of the day, we will be discussing a range of topics from the challenges of climate change and environmental protection to migration and democracy. We will have the opportunity to engage in lively debates and exchange ideas with one another as we work together towards a better understanding of the role that the law plays in shaping our world. Once again, I would like to welcome you all. Today's first plenary roundtable is organized by the Portuguese Society of International Law and the International Law Association of the Singapore branch. It will focus on the role of international law in the fight against climate change and the promotion of sustainable development. We kindly invite the following panelists. Ms. Patricia Galvão Tales, Vice President of the Portuguese Society of International Law, Ms. Nilufer Oral, Director of the Center for International Law of the National University of Singapore, Professor Juan José Ruda Santolaria, member of the United Nations International Law Commission and professor at the Pontificia Universidad Católica del Perú, Professor Fernando Loureiro Bastos from the Faculty of Law of the University of Lisbon, Professor Jean-Marc Touvenan, Professor of International Law at the University of Paris, Nanterre, and Secretary General of the Hague Academy of International Law, and José Luis Pérez Sánchez Cerro, Secretary General of the Permanent Commission of the South Pacific. Without further delay, we give the floor to the chair, Patricia Galvão.
Muchas gracias y buenos días a todos. Bienvenidos al segundo día de este encuentro de las sociedades nacionales de derecho internacional o por el derecho internacional. Me gustaría agradecer en primer lugar a la Sociedad Peruana de Derecho Internacional por nos haber invitado a esta ciudad maravillosa con gente maravillosa para disfrutar un poco de la ciudad, pero poco, pero trabajar. ¿Puedo utilizar eso? Sí, mejor. Pero sobre todo para intercambiar ideas entre los representantes de las sociedades. Es con mucho gusto que en representación de la Sociedad Portuguesa de Derecho Internacional estoy acá con vosotros. Me gustaría también agradecer en particular a la organización, al embajador Oscar Matúa, todo el equipo y sobre todo no puedo dejar de mencionar Gonzalo Tello, que de hecho está siempre ahí un poco en la sombra, pero es la persona quien siempre esté en contacto, procurando siempre contactar los moderadores, que los moderadores hagan su trabajo con sus panas, pero sobre todo dirigiendo esa equipa de jóvenes muy amables, muy competentes. Y muchas gracias por todo. Sí. Gracias. Now let me just switch to English. I think we don't have a fully polyglot panel, but we'll have maybe French, English, and Spanish, not Portuguese, which is not one of the languages of the meetings. But I'm very happy that upon the invitation of the Peruvian Society to the Portuguese Society to put together a panel on these important challenges of climate change and sustainable development, and how international law can contribute in setting the framework for combating and promoting these important challenges. I've also extended on behalf of the Portuguese Society an invitation to the ILA branch of Singapore, and we have here Professor Nilofer Aral, who's online, and she will also say some words on behalf of the Singapore ILA branch, because we thought it was also a good example, and this was done also in other panels, to have a joint effort between different societies in trying to bring together the expertise to discuss this important matter. So I have my task very much facilitated by the previous speaker who introduced all the panelists, so I'm not going to lose time with that, but just to say that we try to focus, of course, climate change and sustainable developments are quite wide topics, but we try to put together a list of issues that we hope then we can continue the discussion, and I really asked my panelists to be very strict on the 10-minute time, and we'll hope that we can leave as much time for discussion. But we'll be covering topics from oceans and climate change to the issues of sea level rise and the possible disappearance of the state, to the possibility of a new legally binding instrument on marine plastic pollution, also to the questions that now are being brought before international courts and tribunals in terms of litigation and what can be expected from that, and then finally latest developments relating on the law of the sea. So it's a broad scope of topics, but they do have this common thread of trying to look at what international law can do with regard to climate change and for the promotion of sustainable development. So without further ado, I will start by asking Dr. Nilofer Aral, who is 13 hours later, so quite late in the night, and thank you so much, Nilofer, for being with us, and I see Fernando is also online. So let me start with you, Nilofer, and also thanking very much your presence and the support of the ILA branch of Singapore, also to the organization of this panel. To you, Nilofer.
Muchas gracias, dear Patricia. Buenos días a todos. And I'm afraid that's the limitation of my Spanish. Greetings from Singapore, and I'm delighted to be participating on behalf of ILA Singapore. I wish I were actually in wonderful Lima, enjoying the beautiful city and the camaraderie, but hopefully some other time. Today, I will be talking about the climate change in the ocean in a broad sense. And I think I will spend, first of all, I would say posing the problematique, and then highlighting what are some of the avenues for international law. Now, I do have a, well, maybe can I do a PowerPoint? Is that allowed, Patricia? I don't know. If not, I'll just...
I think so. If you try to share your screen, I think that should work.
Yeah, it says that the host has disabled the screen sharing. Well, if not, that's fine. Then I will just have to do it without my PowerPoint.
I think we can settle that. No? Enable your permission for sharing the screen. Yeah, we'll do that. Just 10 seconds.
Okay, all right. Oh, very good, excellent. All right, let's see. Let me do the share screen. All right, very good. Thank you so much. Can you see it? Good? Yes? All right, and I will be very good on the time, so I will see. Very good. So I'll talk about ocean and climate change, and I think the first point, of course, is to highlight I think the ocean is often overlooked, and when we're looking at climate change and the problem of climate change, and yet the ocean is 70% of the Earth's surface, and it is absolutely critical and integral to the climate system. And when we're looking at climate change, the ocean is what they call a sinking reservoir because it has been absorbing about 30% of the atmospheric carbon dioxide, meaning that there would be much more carbon dioxide in the atmosphere but for the ocean. And it has also absorbed some 90% of the heat as well. So we would have a much hotter atmosphere but for the ocean. Having said that, however, the ocean in its role as a sink in a reservoir is satiated because of anthropogenic, human-caused greenhouse gases, and for the ocean it really is carbon dioxide. And the result is we have ocean warming, sea level rise, deoxygenation, and ocean acidification. And all of these, one could spend a long time discussing these, but I'm really just going to go quickly. You're all familiar, of course, with the IPCC, and since the beginning, the ocean has been evaluated by the IPCC. And in 2019, they did the first special report on the ocean and cryosphere. And of course, we have the recent 6th assessment report. However, as I will show to you, when we look at the climate change regime itself, the ocean is really very narrowly represented. It really is not addressed sufficiently. When we look at the IPCC reports, and it is important to really understand the science, the ocean is projected to transition to unprecedented conditions with increased temperatures, acidification, virtually certain, and oxygen decline. And of course, the magnitude of these changes will depend on what type of emission scenario we're under. But right now, unfortunately, we're on the high path. Sea level rise, I mean, it's just amazing that since 1900, the level of rising sea levels, according to the science, and these are scientific reports, is more than it has been in the last 3,000 years. Ocean acidification, which is a problem that really came up, just maybe over just 10, 15 years ago, but it is the problem that the ocean has been absorbing carbon dioxide, and that is why it's a sinking reservoir. And to me, it's just really amazing. For millions of years, we had a stable pH balance in the ocean, but because of anthropogenic carbon dioxide that the ocean has been absorbing, it has decreased by 30%. And this has a very deleterious adverse impact on marine life, and which can also alter the marine food chain. So here what I've just tried to do is give a flow chart of the various impacts of climate change on the marine environment, which impacts fish. The fish are migrating. They're going north to colder waters. I think, Patricia, in Portugal, the sardines are moving north, the mackerel in the northern, in the UK. But also from the international law perspective, in addition to the marine environment, it also has impact sea level rise on maritime boundaries, the status of islands, and of course the topic that both Juan Jose and Patricia are studying, human displacement and loss of statehood. So just on looking at where we are in international law, unfortunately there's a dilemma. And the dilemma is that the two major regimes to address the oceans are the Law of the Sea Convention and the UNFCCC, the Climate Change Framework. The Law of the Sea Convention, the Constitution for the Ocean, as comprehensive as it seems to be, is a pre-climate change convention, the regime. Therefore, it was negotiated and adopted before issues such as ocean warming and sea level rise were really on the agenda. The UNFCCC, while it is the principal climate change regime, it specifically addresses climate change. However, the ocean has a very minimal and functional role, which I will show. So when we look at the climate change regime, when we look at the definition of climate system, it does include the ocean under the hydrosphere. However, when we look at the objective of the Framework Convention on Climate Change, it is very atmospheric. The ultimate objective is the stabilization of greenhouse gas concentrations in the atmosphere. The only place that we see reference to the ocean is in Article 4, and here, again, it's a functional role given to the ocean, where the parties are to promote sustainable management and promote and cooperate in the conservation and enhancement of sinks and reservoirs, basically. We move forward to the Paris Agreement. Once again, by 2015, there is so much scientific evidence about the impact of climate change on the oceans, including ocean acidification, yet again, very minimal addressing of the ocean. There's a reference in the preamble. The objective now has been for the first time quantified to a temperature target, and now we know, of course, it's really the 1.5 degrees centigrade to maintain the increase to 1.5 centigrade above pre-industrial levels. Question is, what relationship does that have to the ocean? And particularly when we're looking at ocean acidification. But that's about it. It makes reference to Article 4. All right, so then we move next to the Law of the Sea Convention. And of course, even though the Law of the Sea Convention is a pre-climate change regime, on the other hand, the obligations are such that one could definitely, in my view, interpret them to incorporate climate change, ocean warming, acidification, sea level rise. And one of the issues is whether carbon dioxide could be, would fall into the definition of pollution. And I think there's a very strong argument that it does. It's the introduction by man or human, directly or indirectly, of substances or energy into the marine environment, which results or is likely to result in such deleterious effects as to harm living resources. We see also the obligations to, under Article 192, to protect and preserve the marine environment. It's a due diligence obligation, very broad, and why should it not also include protecting and preserving against the deleterious impacts of climate change? And again, Article 94, I won't go through all of these, but we see that these obligations are important because they also address all sources of pollution, atmospheric, land-based, and vessel sources. And we look at the specific provisions on the convention concerning land-based and vessel source and atmospheric pollution, which are all relevant for climate change. They are all sources of greenhouse gases and carbon dioxide for the ocean. It's clear, states shall. There is a very undiluted obligation for states to adopt laws and regulations. And so I'm looking, how am I doing time-wise? So another issue we have, of course, is sea level rise. And very quickly, what the impacts of sea level rise, again, because the Law of the Sea Convention was a pre-climate change, it really doesn't address this. And the UNFCCC, absolutely nothing on sea level rise, and especially when we're talking about maritime zones. So we know the issue is the question of sea level rise and the impact on baselines. And these baselines that could disappear because of sea level rise, and the issue of whether, one, are they ambulatory? But put that aside, is there an obligation under international law and the Law of the Sea Convention to actually update, resurvey, and redraw these baselines, which if that is done, that means that the maritime zones that are measured from the baselines would shift landward, and with them, of course, the legal regime as well. And this raises many questions. Most importantly is one of legal stability, certainty, and predictability. What about archipelagic baselines? And we know that archipelagic baselines, which something created under the Law of the Sea Convention, it is when the archipelagic state can draw straight archipelagic baselines joining the outermost points of the outermost islands and drying reefs, which can be extremely susceptible to sea level rise. And why is this relevant? Because there's a very complicated formula, and I'm not going to go into the detail, but this complicated formula could be undone. And then what happens to those archipelagic waters that were contained? Another issue for international law, what happens to islands? Can an island that is entitled right now lawfully to all the maritime zones devolve into a rock when it can no longer sustain human habitation or economic life of its own, in which case no exclusive economic zone or continental shelf? And that happens because of sea level rise, loss of territory, but also the loss of the capacity to have, for example, potable water because of saltwater intrusion and other impacts of sea level rise that makes habitation difficult. And this is just, so, what happens to offshore features? This is from Clive Schofield. So anyway, now international law, and very quickly I'm coming to an end. Of course, the International Law Commission, and two of my co-chairs are here. We are addressing these issues. The Law of the Sea issue, we had our first issues paper that was co-authored by myself and Bogdan Oresco, and it was presented to the study group in the International Law Commission that looked at the issues concerning maritime boundaries, islands, but not the marine environment. That we're not looking at. Other ways that now that's being addressed, and I think that may be discussed later on, of course, is seeking of an advisory opinion. One is the Commission on Small Island States has made a request to the International Tribunal for the Law of the Sea. And there's also, on the 29th of March, it's going to be presented to the General Assembly, the Vanuatu advisory opinion that is also include ocean matters as well. So we'll see. There's much to be done because there's still a lot of gaps, and I think it's very important for international law to be proactively engaged in resolving these gaps and addressing these absolutely existential issues in some cases. Gracias.
Thank you so much, Nilofer, for providing us with this overview in such a compact period of time, but you've touched on all the essential issues and how, especially, I think, in the last part of the presentation, all these developments that are currently going on, and all of those are reflections of the attempts of international law trying to address these issues, including through advisory opinions. And now, in a very good segue, not only because I think the three of us, both Nilofer, my very dear colleague Juan Jose Ruda Santalaria, and I are co-chairs of the ILC study group on sea level rise, but also very good colleagues. But it's a great pleasure to welcome Professor Juan Jose Ruda Santalaria, member of the ILC, professor also of the Pontificia Universidad Católica de Peru, to address also one of the issues that we're looking at the Commission on sea level rise, in particular the possible loss of statehood and the legal issues that possibility arises. So Juan José, la palabra es tuya, un grande placer. Muchas gracias.
Querida presidenta y amiga, muy contento de estar aquí, distinguidas personalidades, estimados amigos y amigas. Deseo en primer lugar manifestar mi satisfacción por el hecho que haya llegado a concretarse en Lima el tercer encuentro de sociedades de derecho internacional y, en razón de esa circunstancia, poder compartir con ustedes algunas reflexiones personales, todavía muy preliminares, sobre la importante materia que hoy nos convoca, tomando como base el segundo documento temático que en 2022 presentamos mi buena amiga y presidenta del panel, la profesora Patricia Galbao Teles, y yo, al grupo de estudios sobre la elevación del nivel del mar en relación con el derecho internacional de la Comisión de Derecho Internacional, del que somos copresidentes junto con la profesora Nilufer Oral, otra gran amiga que nos acompaña hoy en forma virtual y que acaba de intervenir brillantemente, y los profesores Bogdan Aurescu y Jacuba Cissé. Al mismo tiempo, quiero destacar lo contento y honrado que estoy al participar en este panel organizado por la Sociedad Portuguesa de Derecho Internacional y la sección de Singapur de la Asociación de Derecho Internacional e integrado por personalidades muy valiosas. Para empezar, cabe hacer hincapié en que la elevación del nivel del mar es un fenómeno global multidimensional que se presenta con características propias en las diferentes regiones del mundo y produce efectos directos e indirectos en todas ellas, aunque reviste naturaleza existencial para los estados de costas bajas y los pequeños estados insulares en desarrollo. Para estos últimos, según ocurre en los casos de las Islas Marshall, Kiribati, Maldivas, Nauru, Palau y Tuvalu, constituye asimismo una amenaza real para su supervivencia, en tanto su superficie terrestre puede quedar totalmente cubierta por el mar o resultar inhabitable. A la fecha, no se registran situaciones en que la totalidad de la superficie terrestre de un estado haya quedado sumergida o se tornara inhabitable. Sin embargo, resulta fundamental resaltar la percepción de los estados más directamente concernidos que aprecian que esta cuestión reviste carácter existencial y no constituye en modo alguno una preocupación teórica lejana. La elevación del nivel del mar es entonces un fenómeno progresivo, no inmediato, que puede conducir a lo largo del tiempo y de manera sucesiva a dos situaciones diferenciadas. Primero, que la superficie terrestre de los estados concernidos puede verse afectada por la erosión y la salinización y tornarse inhabitable, dando lugar a que la población se vea compelida a migrar, aunque no quede totalmente cubierta por el mar la superficie terrestre. Y segundo, que la superficie terrestre de los estados concernidos pueda quedar totalmente cubierta por el mar. Dada la sensibilidad de la materia, cualquier análisis ha de ser sumamente cuidadoso y prudente. A su vez, la evaluación ha de conjugar elementos del ex lata y del ex ferenda, así como considerar un enfoque intergeneracional que tome en cuenta los derechos e intereses de las generaciones presentes y futuras. En ese orden de ideas, si bien no hay una noción de Estado asumida de manera general, resulta pertinente tomar como punto de partida los requisitos o presupuestos que el Estado debe reunir para ser considerado como persona o sujeto de derecho internacional en virtud del artículo 1 de la Convención de Montevideo sobre Derechos y Deberes de los Estados de 1933, población permanente, territorio determinado, gobierno y capacidad para entrar en relaciones con los demás Estados. A propósito de esto último, y teniendo en cuenta la existencia de las organizaciones internacionales y de otras entidades con personalidad jurídica internacional, cabe ajustar el cuarto presupuesto a efectos de más bien hacer referencia a la capacidad del Estado para entrar en relación con los demás Estados y otros sujetos de derecho internacional. El territorio determinado puede ser pequeño o incluso exiguo, pudiendo no haberse definido los límites o ser objeto de disputa con otros Estados su propia existencia. Al mismo tiempo, el Estado ejerce soberanía o derechos de soberanía en los espacios marítimos bajo su jurisdicción en el mar adyacente a su superficie terrestre. El Estado cuenta con personalidad jurídica internacional en la medida en que es destinatario directo y efectivo de derechos y obligaciones conforme al derecho internacional. Como consecuencia de su carácter soberano e independiente, los Estados son jurídicamente iguales entre sí. Una vez que un Estado existe como tal, al reunir los requisitos o presupuestos del artículo 1 de la Convención de Montevideo de 1933, tiene plena capacidad para ejercer sus derechos conforme al derecho internacional, respetando los derechos de otros miembros de la comunidad internacional. Tales derechos no son susceptibles de menoscabo e incluyen el derecho del Estado a proveer a su conservación utilizando los distintos medios a su alcance, entre los cuales se encuentra la cooperación internacional para preservar su propia existencia. Al analizar el fenómeno de la elevación del nivel del mar desde la perspectiva de la condición de Estado, cabe considerar preliminarmente, entre otros aspectos, a. la posibilidad que la superficie terrestre del Estado pueda quedar total o parcialmente cubierta por el mar o resultar inhabitable, así como que no pueda contarse con abastecimiento suficiente de agua potable para la población. En relación con el territorio, resulta oportuno considerar la condición de las tierras y concretamente de la superficie terrestre que quedara sumergida conforme al derecho internacional. B. El desplazamiento progresivo de personas a territorios de otros estados, lo cual a su vez suscita interrogantes sobre 1. La conservación de la nacionalidad o ciudadanía originarias, la adquisición de otra nacionalidad o la posibilidad de emplear figuras de doble nacionalidad o de una ciudadanía común a más de una entidad para evitar situaciones de apatría de hecho. 2. Las formas en las que podría prestarse la asistencia y protección consulares, al igual que la protección diplomática. 3. La situación jurídica del gobierno de un estado afectado por el fenómeno en la eventualidad de que tuviera que establecerse en el territorio de otro estado. D. La conservación por los estados afectados por el fenómeno de sus derechos respecto a los espacios marítimos bajo su jurisdicción y los recursos existentes en ellos, además de los límites marítimos en virtud de acuerdos con los otros estados o de fallos judiciales o arbitrales. E. El derecho a la libre determinación de las poblaciones de los estados afectados por el fenómeno. Una cuestión muy importante a puntualizar radica en el hecho que se planteen medidas orientadas a paliar o disminuir el impacto de la elevación del nivel del mar en los estados costeros a través de la instalación o reforzamiento de barreras o defensas costeras y de diques, así como de la construcción de islas artificiales para albergar a personas afectadas por dicho fenómeno, que son, por cierto, iniciativas muy costosas y cuyo impacto ambiental debe ser evaluado. Se requieren respuestas por parte de la comunidad internacional que de manera previsible puedan canalizarse mediante la cooperación a favor de los estados más afectados por el fenómeno, apuntando a fórmulas duraderas que trasciendan el corto plazo y sean ambientalmente sostenibles. Por otro lado, algunos estados plantean la pertinencia de hacer una distinción entre los requisitos que recoge el artículo 1 de la Convención de Montevideo de 1933 para entender configurado un Estado como sujeto de derecho internacional y asumir que deban considerarse también tales requisitos en relación con la continuidad de la existencia de dicho Estado, especialmente en el contexto de un fenómeno como el aumento del nivel del mar, que no solo escapa a la voluntad de los Estados más directamente afectados, sino considerando además que tampoco han contribuido a generar el cambio climático. La falta de práctica de los Estados en la materia pone sobre el tapete la posibilidad de considerar por analogía algunas experiencias históricas que, si bien no están referidas a la elevación del nivel del mar, pueden aportar elementos útiles al analizar eventuales escenarios o alternativas que podrían emplear los Estados más directamente afectados por ese fenómeno o de aplicar principios de derecho internacional como la igualdad soberana de los Estados, la libre determinación de los pueblos, la cooperación internacional y la buena fe. Las experiencias históricas mencionadas comprenden los casos de la Santa Sede entre 1870 y 1929 y de la Soberana Orden de Malta desde fines del siglo XVIII y hasta la actualidad, que, pese a verse desprovistas en la práctica de jurisdicción sobre un territorio, mantuvieron su personalidad jurídica internacional puesta en evidencia mediante el ejercicio del derecho de delegación y la capacidad para celebrar tratados. También son ilustrativos los casos de los gobiernos en el exilio, en situaciones de, por ejemplo, ocupación total o parcial de territorio de un Estado por otro Estado, donde dichos gobiernos se instalan en territorios de otros Estados amigos y realizan actuaciones a nombre del Estado que sufre la ocupación extranjera, el cual, a pesar de esa circunstancia, no pierde su condición de Estado. Al pensar preliminarmente en alternativas que podrían ser consideradas en relación con la condición de Estado por los Estados más directamente afectados por la elevación del nivel del mar, cabe analizar la pertinencia de la presunción de continuidad de dicha condición, en forma semejante a lo sostenido provisionalmente por la Asociación de Derecho Internacional en su reunión de Sídney de 2018, y las maneras en las que la libre determinación podría ser ejercida por las poblaciones afectadas. A su vez, también podrían plantearse situaciones de mantenimiento de alguna forma de personalidad jurídica internacional, como los casos citados de la Santa Sede y de la Orden de Malta, o recurrirse a diversas modalidades a través de la celebración de acuerdos entre los estados más afectados por el fenómeno y terceros estados, o de la adopción de instrumentos en organizaciones internacionales, especialmente en el marco del sistema de las Naciones Unidas. Las alternativas no se presentan como únicas, pues en función a las circunstancias de cada Estado y a lo que puedan convenir con otros Estados u organizaciones internacionales, cubren diferentes posibilidades en la perspectiva de, por ejemplo, poder conservar la condición de Estado en algunas de ellas, o de integrarse en otro Estado con un importante grado de autonomía y el respeto a los principales aspectos de la identidad de su población en otras. Entre las alternativas que podrían ser consideradas preliminarmente, cabe destacar: 1. La cesión o asignación de franjas o porciones de territorio de otros estados, con o sin transferencia de soberanía. 2. La asociación con otros estados, ilustrada a través de los casos de las Islas Cook y de Nueva Zelanda, así como de los Estados Federados de Micronesia, las Islas Marshall y Palau con los Estados Unidos de América. 3. El establecimiento de confederaciones o federaciones, trayendo a colación ejemplos de algunos estados federales cuyos modelos de organización y de distribución de competencias podrían ser tomados en cuenta. 4. La unificación con otro estado, incluyendo la posibilidad de una fusión. 5. La utilización de eventuales esquemas híbridos que conjuguen elementos de más de una modalidad, para lo cual determinadas experiencias pueden resultar ilustrativas o aportar ideas al formular alternativas o concebir tales esquemas. Muchísimas gracias por su atención.
Muchísimas gracias, querido amigo Juan José, por haber presentado esta cuestión que es sumamente complexa desde el punto de vista jurídico, pero que ilustra muy bien también cómo el derecho puede ser colocado al servicio de este fenómeno físico de desaparición del Estado por una cuestión casi de ficción jurídica con una continuidad de personalidad jurídica, y eso estamos discutiendo en la comisión e incluso con los estados afectados, porque tanto Nilufer, Juan José y yo estamos de partida, Juan José hoy, yo mañana Nilufer mañana para Fiji, para una reunión con los estados afectados para precisamente discutir estos temas. So next I have the honor to introduce my very dear colleague from the Portuguese Society of International Law, Professor Fernando Loureiro Bastos from the University of Lisbon, who is going to speak to us about a legally binding instrument on plastic pollution and some questions and problems. We've heard yesterday about the significant achievement of the BBNJ, and now there is a new process that has started more recently for a new legally binding instrument. So although some say that we're in a multilateral ice age, treaty ice age, there are some signs where the issues are affecting the common interests of the international community. There's movement from states in addressing those issues. So, Fernando, the floor is all yours. I'm very sorry you're not in Lima with us, but we are very glad to have you from Lisbon. Please.
Thank you, Patricia. I'm really very sorry also not to be in Lima, but well, it was life. But I would like to start by thanking the Sociedade Peruana de Derecho Internacional por organizar esta conferencia. Es muy importante las temáticas que estamos a tratar. E, portanto, muitas gracias por organizar e muitas gracias por la invitación a la Sociedad Portuguesa de Derecho Internacional. I'm trying to stick to the time, so I have a small PowerPoint, and I will start. So we are going to talk about the starting point of discussing a new treaty, a new global treaty, an international legally binding instrument on plastic pollution. And because we are just starting the process, I have some questions and some problems that I see for the negotiation. But first of all, it's very important to know that we really have a problem about plastic pollution. Using an article of 2017, the authors say that we estimate that 8,300 million metric tons of virgin plastics have been produced to date. And what they estimate is that by 2050, we'll have something like 12,000 million metric tons of waste. because there is only 9% of recycled plastic and 12% of plastic that is incinerated, so the rest is waste. And for that reason, more or less a year ago, we had in 2 March 2020 in Nairobi, Kenya, 175 countries participating in the United Nations Environmental Assembly adopted Resolution 512 to end plastic pollution towards an international legal binding instrument. And from that resolution, the United Nations Environmental Programme Executive Director convened an international negotiating committee. And the International Negotiation Committee had a first meeting in Uruguay from 28 November to December 2022. And it was a large meeting with 2,300 delegates from 160 countries. And in that meeting, the objective of the treaty is to protect the environment and human health from plastic pollution and ultimately end plastic pollution. The process is just starting, and most likely we are going to have 5 conferences, intergovernmental conference, second in Paris in May, June, the third in November 2023 in Canada, the fourth in April 24. I have a mistake there, sorry. And then the 5th October, November in the Republic of Korea. And the idea is to complete a draft treaty in order to be discussed and approved in mid-2025 by a diplomatic conference of plenipotentiaries. On the 9th December 2022, the executive secretary of this negotiating committee sent a notification inviting written submissions from members of the committee and from observers. And they received 239 written submissions, 55 from members and 174 from stakeholders. And the texts are available online, and it's very interesting to see how diverse the perspectives about this matter are. And what they were asking in these submissions were, first, the substantive elements. What could be the objectives of this instrument? Then core obligations, control measures, and voluntary approach. So how to provide a comprehensive approach to addressing plastic pollution, including the marine environment, throughout the full life cycle in line with the future objectives of the instrument. Then they were asking also about implementation elements, and they were so asking about additional input, other questions like awareness raising, education and exchange of information, research, stakeholder engagement, institutional arrangement, and final provisions. So, what we are going to see most likely in the second conference is a document that is going to be prepared using all these written submissions, and the objective of this document is to have a comprehensive approach that addresses the full life cycle of plastics, how is called by the WNA Resolution 514, including identifying the objective, substantive provisions, including core obligations, control measures, and voluntary approaches, implementation measures, and means of implementation. So, we are discussing a new treaty, and I have some questions and some problems when I'm looking at it. I am not part of the negotiations, so I'm looking at it as an observer, an external observer, looking at what is available online, mainly. So first, my first problem is, it will be possible to respect the deadline for drafting the text of the treaty? Because we are talking about 2 years, 2.5 years. It is possible when we compare with the BB&J negotiations that took 15 years, and we are still, the final text is still being drafted. So first question, first problem. Second one, what will be the objectives of the treaty? So from the first intergovernmental conference, we see that is protect the environment and human health from plastic pollution and ultimately end plastic pollution. So the problem here is how to cover the full cycle of plastics. It will be possible to have such a complex treaty that will be enough to cover from consumption to production to consumption, and to put an end to the plastic era. And then what is the meaning of a circular economy approach when we are dealing with these questions? And one problem that I think is going to be really important is how to deal with third states. Because we saw that 170 something states approved the resolution. The first conference had 160 states. So how are we going to deal with third states that are not going to be part of the negotiations and part of the treaty? Then, third question, third problem, geographical scope of the treaty. So, we heard Nellifer talking about how these questions deal much better with land territory than with the maritime spaces. And the problem is, when we are dealing with something of this kind, dealing with territories is much, much easier than dealing with maritime spaces. The problem is how to deal with obligations of states in the high seas. How are we going to address that problem? And who is responsible for the plastic pollution already existing in the sea, namely microplastics? Fourth question and problem, object of the treaty. So, what type of plastics will be included in the treaty? The questions of microplastics in the sea. When we read about this, we see that there are hundreds, thousands of products that can be included in this treaty. How are they going to be dealt by the text of the treaty? So, most likely, we'll need flexible mechanisms to amend the treaty, the text of the treaty, according to scientific and technological advances in this field. Then the fifth problem will be about domestic implementation and capacity building. The question is how to achieve a national implementation system that takes into account the particularities of different communities and different levels of economic development. For sure, we have a problem of plastic pollution, but I think it's not going to be easy to address it with just one model of solution that can fit all countries and all communities and all different levels of economic development. Sixth problem will be the relations with other international legal regimes. It is possible to create a regime that does not overlap with other existing ones. If we see some of the documentation and people are dealing with this treaty as a human rights treaty and as an environmental law treaty, we see that some of the comments are establishing relations with dozens of treaties. How is going to be possible to organize the coordination, the harmonization with all the other international legal regimes. In particular, when we are looking from a law of the sea perspective, how it's going to be possible to have a compatible regime with UNCLOS and with the new BBNJ treaty. And for instance, I'm putting here Article 4 of the BBNJ treaty, just to see how difficult it is to harmonize treaties when we are dealing with the law of the sea. The seventh problem would be institutional arrangements. What type of institutional arrangements? One thing that is very interesting to take into account is a system similar to paragraph 4 of Article 48B's transparency of the BBNJ Treaty. The representatives of states not party to this agreement, relevant global, regional, sub-regional, or sectoral bodies, indigenous people, and local communities with relevant knowledge, the scientific community, civil society, and the other relevant stakeholders with an interest in matters pertaining to the Conference of the Parties may request to participate in the meetings of the Conference of the Parties. This is a very interesting model. Most likely it's a way to deal with third parties and is a way of deal with a range, a very extensive range of stakeholders. The eighth problem, it's about reservations. Is going to be possible to accept reservation to this treaty? Because we have several possible approaches to it, but even if it is a human rights treaty, it would be possible to have reservations. So, and how to deal with reservations and the main core of obligations of the treaty. And finally, it would be very interesting to see if we are going to have a specific settlement of disputes mechanism. Because we are going to deal with very, 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 very technical questions. And for that reason, it would be most likely very interesting to have something similar to what was achieved in the BBNJ Treaty. Article 54 ter, where a dispute concerns a matter of a technical nature, the parties concerned may refer the dispute to an ad hoc expert panel established by them. The panel shall confer with the parties concerned and shall endeavor to resolve the dispute expeditiously without resource to binding procedures for the dispute of settlements under Article 55 of this agreement. So, we are starting the discussions. So, most likely, many of my concerns will be overcome and will be not a problem. But it is going to be very, very interesting to see a first text and how long it's going to take to achieve a final text and a treaty, an international legal binding instrument on this matter. I'm very optimistic about it because we can say that there are no one is disputing the necessity of achieving it, but a completely different thing is to have a final text to be signed and ratified. So thank you very much for your attention, and it was very good to share with you my thoughts about it.
Muito obrigada, Fernando. Thank you so much for drawing our attention to this new development and also for highlighting a number of important legal questions that certainly will be thoroughly discussed during the negotiations. And if we manage to achieve BBNJ, although it was 15 years, I'm sure we will do it also with the plastics pollution treaty. So now maybe in French, Jean-Marc? No? In English? Okay. So we will have now the pleasure to listen to Professor Jean-Marc Thévenin from Nanterre University, Secretary General of the Hague Academy, who I'm just going to read the title because I think it's quite provocative title, but you can come on the presentation. In the case States versus the Earth, what to expect or not from international judges. Jean-Marc, c'est à toi. Merci.
Good morning. I'm indeed representing the Hague Academy of International. I'm very proud of the Hague Academy of International, I must say. I think that most of you know this marvelous institution, but perhaps not all of you know that the institution began its journey 100 years ago, in 1923. So it's the centenary we celebrate this year. And I was wondering, listening to all that, whether in 100 years from now, the Hague Academy will still exist, or will everybody and everything be burned? So if I ask that question to a politician, he will say, don't worry, we will deal with it. And the Academy will survive 100 years more. In France, one politician said once that promises are only binding on those who believe them. That sort of posture is amazing. Sometimes politicians stick to their promises, but in general, it's promises that no one asks them to put forward. I have examples, but I won't be rude with France. Now, the real issue when it comes to the necessary measures to be taken to fight against the global warming by reducing the emission of greenhouse gases is that governments are not consistent. They promise a lot, but they do not enough. I say so not in the air, but under the authority of the French Conseil d'État. And this is just an example. There are many other examples, so I'm not focusing on France, but I can bring to you this example. I refer here to a case brought before the Conseil d'État by a French municipality living from tourism. And this municipality claimed that the French government was not taking appropriate measures to curb the greenhouse gas emission produced in France, and therefore did not comply with France's commitments, undertakings with respect to climate action. The Conseil d'État, in a judgment of July 2021, agreed with the applicants that France was simply not acting credibly in order to reduce the emission of greenhouse gases by 40% at the horizon of 2030, as it had committed to. In judging the French inaction as unlawful, the French Conseil d'État specifically referred to the UNFCCC and to the Paris Agreement, as well as to the European Union law, which is trying to implement these international commitments. The applicant then cites the European Court of Human Rights against France for failure to take sufficient climate action, claiming that this inaction is in breach with Article 2 and 8 of the European Convention on Human Rights. And Article 2 is about right to life, and Article 8 is about right to respect for private and family life. And we can understand why family life is at stake, because when you have children, in general, it's your family and you think of their future, and you think that perhaps this future is not very much taken into account when it comes to climate action. So that's interesting. I think it's interesting, don't you think so? Well, in fact, there are now 6 climate applications before the European Court of Human Rights, 6. And they're pending, waiting for treatment after the Grand Chamber, because it considers it's important. The Grand Chamber will have made its position in currently 3 emblematic climate requests. So what's the purpose of all this? What for? The challenge for applicants is to convince the judges that non-respect of the commitments agreed under the Paris Agreement is a breach of the European Convention on Human Rights. In other words, the challenge is to try to, if I may say so, set up human rights teeth for biting those who do not hold on their climate promises. A lot of expectations. The same expectation, same kind of expectation is now before the Inter-American Court of Human Rights, and I think you referred to that yesterday in your opening lecture. I don't know if everybody knows about that, but there is an amazing request for advisory opinion before the Inter-American Court of Human Rights, which is sort of the same as the one which are before the European Court of Human Rights. Well, it could have been better done, to be honest, because if you read the application, the request, there are many questions, but not a clue on how the judges could deal with it. I suppose that parties to the Inter-American Convention will provide some advices. I would be very happy to help if necessary. The same expectation, sort of the same expectation, is now before the ITLOS. We discussed that a little bit. An international organization, the COSIS, indeed was courageous enough to put to the ITLOS a challenging question, which is whether Part 12 of the UNCLOS has something to say about global warming, and more precisely about the causes of global warming, which is the emission of greenhouse gases, and it has been touched upon already. And the funny thing is that it will go very fast before the ITLOS. I think that the pleadings, the hearings, will be organized somewhere next autumn. So it will be a very quick movement. And of course, we are also expecting some news from Vanuatu and the General Assembly soon. Well, the question is really challenging, I would say, but that's interesting and it will need a lot of thinking. So what can we expect from judges? And that was my question. Of course, I don't have the answer. What I can say is that what can be expected from them is wisdom. And to help them, what can be expected from the international community is that it participates, in French we would say en masse, to all these proceedings, as much as possible, to show to the judges how crucial is what they will say. It can be a game changer, or it can be nothing. And my expectation from perhaps the Society for International is to engage in these discussions and to say what they would like the judges to say. Wouldn't it be interesting to think about that, of what could be the role of a Society for International in such a moment where the earth is burning and where judges are requested to say that. Perhaps it would be interesting to think of providing them some food for thought, as we said yesterday, useful food for thought. I'm sure it would be the case, and I put that on the table for further discussion. Thank you.
Merci beaucoup, Jean-Marc, and I think really what you said about expectations is really important because we are at a unique moment where we have this number of requests from ITLOS. We will have the one ICJ. The resolution will be adopted next week on the 29th, and the one before the Inter-American. And what could be the role of civil society also in participation on those proceedings, though not formally, but in making submissions through states or directly if there's room for that. So the call for the societies for international law to think about how to also feed on that process is a very interesting one and might be discussed maybe in the closing session. So, last but not the least, tengo el placer de pedir al embajador Cerro que haga su presentación sobre los latest legal developments, current legal perspectives on the law of the sea. Por favor, embajador, tiene la palabra y si cumplimos con todo, tenemos todavía 10-15 minutos para discusión. Por favor.
Buenos días, honorable presidenta, distinguido auditorio. Al haberse cumplido 70 años de creación de la Comisión Permanente del Pacífico Sur, podemos mostrar con orgullo la tarea cumplida por nuestro organismo internacional. Esta ha desarrollado una labor que cumple con los objetivos fundacionales para lograr mejores condiciones ambientales que repercutan en beneficio de la biomasa y de las poblaciones costeras. Creemos que este reto espera una respuesta clara y contundente de parte nuestra, pues si ayer fue la revolución industrial, hoy lo es la revolución por la supervivencia del océano y de la raza humana. En el mismo acto de la creación de la Comisión Permanente del Pacífico Sur, el 18 de agosto de 1952, fue firmada la Declaración de Santiago como una nueva forma de concebir el mar, es decir, ya no como un espacio militarizado o de seguridad, como lo había sido por más de 2000 años, sino con un clarísimo concepto socioeconómico donde lo relevante ya no eran las aguas en sí mismas, sino sus recursos. La célebre Declaración de Santiago de 1952 revolucionó la historia del derecho del mar al unificar las posiciones unilaterales de los países firmantes que establecieran como norma de su política internacional marítima la soberanía y jurisdicción del Estado costero hasta las 200 millas. No obstante, ello no significa el desconocimiento de las necesarias limitaciones al ejercicio de la soberanía y jurisdicción establecidas por el derecho internacional a favor del paso inocente e inofensivo de las embarcaciones a través de la zona señalada para las naves de todas las naciones. La Comisión Permanente del Pacífico Sur es una alianza, es una opción estratégica, política y operativa en el Pacífico Sudeste para consolidar la presencia de los países ribereños en dichas áreas geográficas y su proyección de manera efectiva y coordinada tanto hacia las áreas aledañas como al vínculo con la cuenca del Pacífico. La fortaleza jurídica está en más de sus 30 convenios, acuerdos, protocolos, declaraciones, estatutos y reglamentos generados durante estos 70 años por la Comisión y por la vigencia de sus objetivos fundacionales. La Comisión Permanente del Pacífico Sur es un organismo internacional y por lo tanto es una persona jurídica de derecho internacional, de conformidad con lo establecido en el Convenio de Paracas de 1966. Es el más importante órgano regional de coordinación de políticas marítimas y es un órgano permanente que este año cumple 71 años de existencia y está basado en la ciudad de Guayaquil, Ecuador. Tiene un secretario general de la institución, que es quien les habla, quien a su vez es el secretario ejecutivo del Plan de Acción del Pacífico Sudeste. Haciendo un poco de historia, debo decir que por primera vez 3 naciones de nuestra región, en 1952, Perú, Chile y Ecuador, fijaron el límite de las 200 millas como norma de su política internacional marítima, es decir, soberanía y jurisdicción en el mar que baña sus costas. El cuarto país que se sumó fue Colombia, mediante su adhesión en 1979. Los cuatro anunciaron al mundo la tesis de que en esa distancia marina de 200 millas, los recursos vivos, los peces, y no vivos, los minerales, que allí se encuentran, les pertenecen, por lo que sin su autorización ningún otro Estado podrá ingresar a explotarlos. Nuestros científicos, diplomáticos, académicos, militares, etcétera, que asumieron con convicción la innovadora visión del mar, fueron claves para lograr que en 1982, en que fuera abierta para la firma la Convención del Mar, esta fuese incorporada de manera intacta en las legislaciones nacionales. La denominada Constitución de los Océanos es considerada uno de los tratados más importantes de la historia desde la aprobación de la Carta de las Naciones Unidas. De otro lado, existen las llamadas secciones nacionales que constituyen instancias de enlace, facilitación y coordinación permanente entre las instituciones nacionales de cada país miembro. Estas son integradas por altos funcionarios de los Ministerios de Relaciones Exteriores, quienes actúan como representantes ante la CPPS. El año pasado hemos celebrado los 70 años de la CPS. Esta nació para coordinar y fomentar las políticas marítimas de los Estados miembros para la conservación y uso responsable de los recursos naturales y su ambiente en beneficio del desarrollo integral y sustentable de sus pueblos. La reunión se realizó exitosamente aquí, en la ciudad de Lima, en la sede de la Cancillería peruana, a nivel de los ministros de Relaciones Exteriores de los países miembros y de sus representantes. Igualmente, el año que acaba de terminar, se cumplió el 40 aniversario de la Convención del Mar, abierta a la firma en diciembre de 1982, la cual es considerada como el instrumento idóneo para garantizar el normal y justo desarrollo de las actividades sobre los mares, sus lechos y subsuelos, para promover el uso pacífico, la protección, el estudio y preservación de su enorme riqueza. Los espacios marinos, inclusive que exceden 10 veces las superficies terrestres. Es también la llamada Constitución de los Mares. Debemos comenzar a saldar la deuda social que mantenemos con los hombres de mar, comenzando por concluir su formalización y tantas veces postergada, así como su incorporación al mercado, al crédito y a los demás derechos. Necesitamos reformular nuestras políticas para que la promoción de la acuicultura sea algo más que un enunciado vacío y que la industria atunera no siga siendo demolida. Actualmente el océano está bajo amenaza. Las actividades humanas y la pesca se han intensificado y expandido, y se ha desarrollado un rango de nuevas actividades como la exploración del petróleo y gas y la potencial minería en el suelo marítimo. Estas actividades económicas han generado polución, sobreexplotación de recursos y destrucción de hábitats críticos. Por ello considero importante fomentar entre nuestros países actividades de cooperación que permitan acciones conjuntas en la lucha contra el cambio climático, particularmente para entender los factores de este fenómeno que inciden en el océano y en la conservación y el aprovechamiento sostenible de la biodiversidad. Pero todavía me faltan algunas partes, entonces no puedo concluir ahora. Después, la discusión la haremos al final. Gracias. Actualmente, por ello, considero importante fomentar entre nuestros países actividades de cooperación. El optimismo político-social que en parte marcó las 2 primeras décadas del siglo XXI, se dio frenado en 2020 por la emergencia sanitaria generada por la propagación del virus COVID-19 y sus diversas mutaciones que ocupan nuestra atención hoy en día. Esta crisis sanitaria tuvo un pronto y radical efecto global al encontrar a un mundo ampliamente interconectado con más de 7.000 millones de habitantes y con múltiples y muy activas rutas de transporte de bienes y de personas. Bueno, a mí me parece una descortesía lo que me acaban de pedir. Yo traía un discurso preparado de unas 8 páginas y realmente no puedo concluir porque se me ha pedido concluir prematuramente. Entonces, en virtud de ello, voy a concluir y en todo caso les agradezco a todos ustedes por la atención prestada. Muchas gracias.
Son las instrucciones que tenemos de la organización. Agradezco a todos por el esfuerzo de cumplir con los 10, 12 minutos y así nos da unos 10 minutos ahora. We have about 10 minutes for discussion. So we very much welcome questions. I know there was at least one question that was signaled to me before and then a second one. So 3 questions. So we'll take those 3 questions. Maybe I'll ask you to ask your question and then we'll give the panelists first the possibility. I don't know if there are microphones. Thank you very much. So we have one first question, which I think it's coming on the right to a healthy environment, if I understood correctly.
Thank you very much. My name is Daniel McGraw. I'm a member of the American Society of International Law and the President Emeritus of the Center for International Environmental Law. Thank you for this excellent panel. It's raised a lot of the issues in this interlocking existential threat that we are all facing. What I'd like to ask about is a particular human right question, and that is, as you probably know, on July 28th this last year, the General Assembly recognized the human right to a healthy, clean, healthy, and sustainable environment. And the vote was 161 to 0 to 8. It was the most overwhelming approval of a human right in the history of the General Assembly. And there are 2 parts to my question, really. One is, what role do you think that can play in dealing with these different issues you've raised? And the second is, how can the international law societies help forward that and other claims that, as we've seen, a lot is happening right now. There are people in this room that will be alive in 2300. I mean, these are problems that are very much with us. We have to do something. The American Society of International Law, of which my wife is a former president, we're not used to making statements about this kind of issue. But I feel we need to, because the issue is just too important to humanity and to the planet. Thank you.
Thank you so much. Shall we take your question and then we'll come back to the panel? Now we have Miguel, please, here in the first row.
I actually have more a word of encouragement than exactly a question. And I'm not speaking as legal counsel of the United Nations, but former Secretary General of the Intergovernmental Conference for BBNJ. So, Professor Loureiro Jubas, not 9 problems, but 9 issues to solve. And what I've learned from this very complex negotiation is that when member states are ready to compromise, they do it. BBNJ was an extraordinarily complex treaty and not technical, highly political. The issue of sharing of benefits from genetic marine resources, it's a political issue. It's not a technical issue. And yes, it was 20 years of discussion, but really, since 2017, 2 years of COVID for interruption, and without the sense of environmental urgency and emergency that we have nowadays. And this is a big stimulation for member states to work seriously on these matters. Also, huge presence of civil society, and with a very important role in this process, High Seas Alliance and so on, youth. And I'm not saying this because it looks progressive and modern to invoke civil society. No, they had a role. They were in the room all the time. And that was a booster also. And let's be frank, some pressure on member states. Finally, Professor Jean-Marc Touveneur, excellent idea. It's not for the judges and lawyers to solve all these existential issues, but put the academic societies, the société savants, to some use. Not just the clubs of old friends who pet each other by articles that, frankly, nobody will read, but to put your science at the service of these important causes and contribute actively to the very complex legal issues that we have to deal with. Thank you.
Thank you so much. So one last question. The lady just behind. Yes, please.
Thank you. I'm going to speak in Spanish, so everybody can traduce, please. Siguiendo lo expuesto por las preguntas, que más que preguntas son excelentes sugerencias, gracias, embajador Sánchez Cerro, y felicitando, por supuesto, al embajador Oscar Maurtua por esta. Yo creo que es un momento en el mundo en que las sociedades, en que las academias, en que todos no solamente tenemos que discutir y reunirnos, sino exigir a los gobiernos locales, al Congreso de la República, a los diferentes congresos del mundo, con proyectos de ley, porque ellos son los que deciden las políticas públicas, la educación en las currículas, porque si no hay educación en el mundo con los niños para salvar el mundo, pues nos damos cuenta recién de toda esta problemática, ni siquiera cuando tenemos uso de razón, sino cuando ya estamos en desuso de razón. Por favor, yo creo que es momento en que tenemos que ponernos el pecho y la frente y hacer que los gobiernos se pongan el pecho y la frente, la mano y la responsabilidad penal de no estar realmente tomando decisiones para salvar el mundo. Como bien dijo, ya no son las 200 millas que protegemos el mar peruano, escenario milenario, y en todo el mundo que tienen esa bondad de la creación del mar. ¿Y qué hace? Es la destrucción del hombre por el hombre. Entonces, hay que exigirle. Esto más que una pregunta es de todo corazón y respeto. Hay que ponernos fuertes y las academias, las sociedades, presentar proyectos de ley y exigir que sean aprobados en el Pleno, porque yo no creo que se estén realmente exigiendo a los gobiernos locales, repito, a los gobiernos del mundo, esta problemática a resolver urgente. Con todo respeto, muchas gracias.
Muchas gracias. No sé si tenemos tiempo para porque pienso que, bueno, tenemos más comentarios que cuestiones. Pero le pedía que sea muy rápido.
Sí. Muchas gracias. Voy a ser muy puntual, profesor Mansi, de la Asociación Argentina de Derecho Internacional. Como debo ser puntual, por supuesto, agradezco mucho a la profesora Galván-Teles y a todos los oradores que nos han precedido. Sugiero que, por ejemplo, la parte que no pudo exponer el embajador Sánchez Cerro, que es muy interesante, tal vez esa parte se nos pueda facilitar por escrito en algún momento, porque tendríamos que poder beneficiarnos con ello, dado que sentó una serie de cuestiones que a veces se están dejando de lado. Y a propósito de todo ello, cuando se han adoptado nuevos tratados, por ejemplo, el que modifica la parte 12 de la Convención, a la parte 11 de la Convención del Mar, o el Acuerdo de Nueva York de 1995, donde se dice que se hace in the framework of the UNCLOS Convention. Cuando se dice eso, y inmediatamente existen artículos que son incompatibles con la Convención de Derecho del Mar. Entonces, ¿qué quiere decir in the framework and consistent with UNCLOS? Eso ocurrió en 1995, ocurrió en Roma en 2009, y con respecto a BBNJ, es importante tener en cuenta lo que dice el doctor Serpa Suárez. Ahí lo que subyace es la política, la geopolítica, motivada generalmente por países con fundaciones a través de las cuales desde el año 2004 venían participando e insistiendo algunas ONGs especialmente interesadas en o vinculadas a los intereses geopolíticos de algunas potencias. De allí, para terminar, volviendo un poco a la excelente exposición del profesor Le Touvernat, me pregunto, hablamos de cumplimiento por los estados de derechos humanos, de los derechos humanos. ¿Cómo se hace cuando se olvida las responsabilidades históricas y al mismo tiempo las comunes y diferenciadas, los intereses de los países en desarrollo y sobre todo cuando se trata de países que no son partes en las convenciones internacionales sobre derechos humanos o sobre algunas de ellas, y se trata muchas veces de importantes países hegemónicos del hemisferio norte? Por eso es que mi pregunta va dirigida más que nada al profesor Le Touvernat. ¿Cómo se actúa, así como ocurrió en Francia a partir de un municipio, cómo se actúa cuando hay grandes responsables y responsables históricos principalmente y que no son parte de las convenciones internacionales de derechos humanos o en alguna de ellas? Creo que he sido lo más breve posible y les agradezco también el tiempo conferido.
Muchas gracias. Pregunto a la organización si tenemos unos minutitos para contestar. Sí, bueno, gracias. Entonces, I would ask whoever wants from the panel. I know Professor Oral had to log out because it was really getting quite late. But I think besides all the comments that were made, that I think we need also maybe to integrate in the discussion in the afternoon on what would be the roles of the societies also with regard to disseminating, promoting the right to a healthy environment, and also in the contributions, possible contributions to these advisory proceedings processes. I think there are two questions. One would be, how the right to a healthy environment would be playing a role in the discussions that we're having here, and the other one would be, if I understood correctly, the question, which was more directed to Jean-Marc, on the responsibility of states in this regards, and how to make the link. So, but I would ask the panel, whoever wants to comment, to please take the floor. Jean-Marc, please. The microphone.
So I'm not sure I got all the questions right, but I have three small comments to make. One is regarding the right to a healthy environment as a human right. That's great, of course. That's great. It reminds me the story of the advisory opinion OC23/17 that you probably know, advisory opinion of the Inter-American Court of Human Rights on the relationship between human rights and the treaties protecting the environments. So when we prepared this request with my friend Ricardo Abello, because we were working on that, the issue was to try to link the problem with the convention itself and to avoid the San Salvador protocol, which is about which provides the right to a healthy environment. Why did we try to link the problem with the right to life? It's because this is something you can bring before the courts in a contentious manner, so it gives better teeth, right? So that's perhaps the issue when it comes to proclamations. Well, that's nice to hear, that can help interpreting things, but ultimately the real issue is to find a judge who can say to those who commit to protect the environment and human rights, do it really, and now. The second idea I wanted perhaps to share is the balance between the political approach, which is of course essential. The multilateralism is alive, I completely agree, and I will say so this afternoon as well. But, you know, I don't like really much when people say that's all blah, blah, blah. You know, the famous sortie of Grunberg, but sometimes it's a little bit like that. And this is why, at a certain point, we need judges. And this is why I think it's useful to ask them, what do you think of the value of the commitments made by states regarding the protection of the environment? And the last thing is about perhaps what I understood about the responsibilities of states under the human rights conventions regarding global warming. I think it's quite simple what the European Court said, or works on, and what the Conseil d'État said in France. Very simple. Do what you promised to do. Well, if you did not promise, it's more complicated. But if there are promises, do it. I think that's the beginning of the story, and then we can perhaps go further.
Thank you very much. I wonder if other panelists, Professor Ruda, Juan José, por favor.
May I have 1 minute?
Muchas gracias. Muy brevemente, no quería dejar de hacer algunos comentarios muy puntuales. La primera cuestión en relación al tema de los derechos humanos y el derecho de acceso al medio ambiente. Yo quisiera resaltar una cuestión tremendamente importante en esto, que creo que es transversal: la necesidad de un enfoque intergeneracional, pensando en las generaciones presentes y futuras. O sea, no podemos quedarnos simplemente con una mirada focalizada en el momento presente, hay que proyectarse hacia el futuro. Luego, absolutamente medular también la perspectiva de materializar en forma concreta la vigencia real de estos derechos, la necesidad de la cooperación internacional, y la necesidad de la cooperación internacional a propósito, por ejemplo, de casos como los que comentábamos, estados de costas bajas y sobre todo pequeños estados insulares en desarrollo que no han generado la situación que vivimos ahora por el calentamiento global y que requieren de una cooperación para hacer frente justamente a un fenómeno causado por toda esta circunstancia como la elevación del nivel del mar. Y ahí nos topamos igualmente con situaciones que atañen a los derechos de las personas. ¿Qué pasa, por ejemplo, si un territorio no queda totalmente cubierto por el mar, pero eventualmente no se cuenta con agua potable suficiente para asegurar la supervivencia de esas personas en esos territorios? ¿Qué pasa con eventuales situaciones de apatrida de facto que pueden efectivamente producirse? Y luego, sumamente interesante, esta aproximación que planteaba nuestro buen y querido amigo don Miguel de Serpa Suárez a propósito de la mirada jurídica, pero también política, desde la perspectiva de las negociaciones internacionales y de los instrumentos internacionales. Por eso también me parece muy importante no perder de perspectiva que muchos de estos desarrollos incorporan aspectos de lex lata, pero también de lex ferenda, es decir, hay cuestiones que parten del derecho existente, pero hay cuestiones en donde tendremos que generar justamente a partir del desarrollo progresivo del derecho internacional respuestas ancladas en el derecho, pero respuestas que nos permitan responder a nuevas situaciones que se están produciendo y que requieren respuestas concretas. Luego, tremendamente importante también la referencia a propósito de los currículos y de generar conciencia en términos precisamente de la necesidad de preservar el medio ambiente, pero también conciencia en relación a cómo detrás de toda esta situación están no solamente los derechos de los estados, sino los derechos de las personas, y cómo resulta tremendamente importante en esa perspectiva reforzar la cooperación internacional a nivel de estados, de organizaciones internacionales, pero también de entidades de la sociedad civil, y aquí sin duda intervienen las sociedades de derecho internacional, las secciones nacionales de la Asociación de Derecho Internacional y otras entidades representativas. Y por otro lado, me parece muy importante la referencia a propósito del contexto particular de los estados en desarrollo y en ese sentido la necesidad imperiosa de poder dar respuestas que partan de constatar esa situación y de la necesidad de justamente canalizar a través de respuestas concretas una cooperación internacional que en términos efectivos permita responder a fenómenos como los que hemos estado comentando hoy. He intentado hacer algunas pinceladas y nuevamente agradecer enormemente esta magnífica oportunidad a la Sociedad Peruana de Derecho Internacional y a quienes nos han convocado. Muchas gracias.
Muchas gracias. Embajador Sánchez Cerro, ¿le gustaría hacer algún comentario?
Gracias. En realidad yo he venido ayer de Ecuador, donde resido, y en medio de una tormenta fenomenal, y realmente me siento sumamente preocupado que no se me haya dejado hablar, a pesar de que yo he hecho el esfuerzo de venir y tenía otros compromisos como secretario general de la Comisión Permanente del Pacífico Sur, pero realmente me siento muy mal que habiendo gestionado todo un viaje para venir a estar con ustedes, que me parece una magnífica oportunidad que nos da el embajador Maurtua, y realmente no deseo aportar nada en esta ocasión por las razones que les he explicado. Gracias.
Gracias y una vez más, bueno, como moderadora nuestras disculpas, pero las instrucciones que teníamos. Un comentario final de Fernando, 1 minuto para terminarnos. Fernando, por favor. Micrófono. Unmute.
Thank you very much. Just 1 minute, just to say thank you very much, Miguel Serpostuar, for sharing your experience about the BBNG treaty. For sure, this is a very important treaty and the result to achieve. My worries, and I'm going to change problems for issues, but my problems is about the 30 states that are not participating in the negotiations. We are going to create a conventional regime. We are going to create a treaty, and third state, for me, it's the most important question. What we are going to do with those states that are not participating? So that's just what I want to say. Thank you very much.
Well, thank you so much to all the panelists, also to all the questions. I know we didn't have time enough for all the presentations and also for all the questions because I saw other hands being raised, but that just shows that issues related to climate change and sustainable development are really at the core of our concerns today, and that's additional motivation also for the societies for international law to work on these issues and discuss them together. So help me in thanking the panelists on Zoom and here. Thank you very much.
Dr. Oscar Schiappa Pietra. He is a member and executive director of the Binational Plan in the Peru chapter. He is member of the Peruvian Society in International Law. Professor Ana Salinas de Frias, ad hoc judge for the European Court of Human Rights and president at AEP-DIRI. Professor Aiko Nakai, he is an associate professor at the Osaka Metropolitan University and member of the Japanese Society of International Law. Professor Pablo Martínez Rodríguez, he is professor of International Law and European Law at the University of Granada. Professor Shinji Sawada, he is a member of the National Defense Academy of Japan. And Professor Isabel Recabarren, who directs the Center for Studies for the UEALC. She is a doctor in international law and economic, and she has coordinated 2 legislations in the for the Parliament, for the Eurolat Parliament. Without further ado, we give the floor to the chairman.
Well, thank you very much. Just to go straight to the point, I guess the reflections we are about to share this morning cannot be more timely in a context in which democratic values, democratic rules, and democratic governance are suffering a very significant regression, both at the global scale and at the national level. And we are facing a scenario in which we are simply witnessing what is happening, and we are still not being able to provide responses to this democratic crisis. I personally have been studying in the last years about global constitutionalism, and I have reached a point in which I have started questioning the relevance of such an exercise in considering that we are facing a process of very significant fragmentation in the international scenario and of huge polarization. So, well, without further ado, our first speaker will be Professor Ana Salinas de Frias. Professor Ana Salinas, please go ahead. Thank you.
Hello?
Yes, please go ahead. Adelante, por favor.
Hello?
Sí, le escuchamos. Adelante, we hear you. Sí, ya, adelante, por favor, la escuchamos. No, no la estamos escuchando. Shit. Sorry. Un momentito, por favor. Sí. Usted está probablemente en muted. Sí. Usted está silenciada en su computadora. Ahora sí le escuchamos. Adelante, por favor.
De acuerdo, perfecto. Thank you very much. Before starting, I would like to invest 2 first minutes to thank the organizer for this kind invitation they have done to the Spanish Society of International Law, and allow me to do it in our beautiful common language, the Spanish. Muchísimas gracias por esta invitación a la Asociación de Profesores de Derecho Española de Derecho Internacional y Relaciones Internacionales, de la que me enorgullece ser presidenta, y en nombre de todos ellos les agradezco la invitación a participar en esta mesa redonda y la pena por no haber podido participar en persona, tanto el profesor Martín Rodríguez como yo misma. Thank you very much, and I will go straight to the point because I know we have just few time. The international system uses continuously, since the end of the 20th century till nowadays, uses continuously the term rule of law and democracy. And it has been used, for instance, by international leaders, international organizations. I think now of the refundation of the NATO, for instance, the funding values of the European Union, of course, of the Council of Europe, etc. Terms as protection of human rights, democracy, of the rule of law are used. Sometimes it seems to be used in an equivalent manner. Of course, they are not exactly the same, and perhaps many authors, perhaps because many authors so establish or so assume the rule of law is the more comprehensive principle of these three main concepts, so subsuming the two previous ones, the protection of human rights and also democracy. At the same time, the use of the term governance is gaining space, is gaining room, and a central role also at the international level and also within the international legal system being more and more used, together with this idea of a constitutional system. We have even celebrated the UN International Year of the Rule of Law and the aspirational governing principle of the international society, either at the political level, but also at the international legal level. International legal order must constantly defend and reassert its foundational elements against internal and external threats or doubts or attacks. Some claim that during the past decade, the contestations have ascended to a new level and may challenge the core integrity of the international legal order. I would like to make here 3 points. First, it is possible to identify some foundational elements of international law that can be generally accepted by all states. Second, can such core elements reach a normative threshold to be considered requirements rather than values or just virtues? Third, and finally, what are these core requirements of the international rule of law? Challenges now facing the world are to be overcome, among other elements, obviously, by the means of rules internationally agreed, internationally implemented, and, if necessary, internationally enforced. That is what the rule of law as it stands at the domestic legal systems would advise, and requires also, it seems, at the international order. We will discuss over that. Because, however, the rule of law has been considered as sort of a blank term that appears to be overused, of limited analytic value, rather a descriptive value, and potentially distorting. The international rule of law has not developed into a vacuum. Its conceptual roots, practices, and reflections in judicial decisions inevitably draw from the notion of the rule of law at the internal level. Nevertheless, the domestic rule of law concept cannot be simply transposed, implemented, or internalized by the international legal system. For very well-known reasons, the horizontal hierarchy of actors, in the case of the international arena, the decentralized lawmaking, the lack of effective judicial review mechanisms, and pluralist notions of justice, to mention but some of them. James Crawford has expressed the view that the international rule of law, as analogous to the domestic concept, is conditioned by certain facts, notably the absence of legislative power such as it exists in domestic legal systems, and the correlative need for many decisions to be made by consensus of states. For similar reasons, Hisashi Owada calls for a reconceptualization of the rule of law in the international context, even though certain elements of the rule of law remain so essential that they should be applicable also in interstate relations, the same way they do in the domestic realm. The question of the rule of law as a legal concept and as a political idea is reflected throughout the debates at the UN. In 2004, the concept was given substance when the Secretary General attempted to define it in a long assertion that I quote, "A principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. It requires as well measures to ensure adherence to the principles of supremacy of law, equality before the law, accountability before the law, fairness in the application of the law, separation of powers, participation in decision-making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency." This long definition proposed by the Secretary General, the UN Secretary General, speaks we don't know exactly if he intended to propose a formal definition, but in fact the way in which it defined it speaks more to the rule of law as it is understood at the domestic level and not at the international level. While no formal definition of the rule of law had been agreed upon by member states, the discussions began to gain importance in 2005 when the World Summit was held. The normative relevance of the rule of law was becoming recognized as an increasingly relevant reference point against which the behavior of states is assessed under international law. In September 2012, the UN General Assembly held a high-level meeting on the rule of law at the national and international levels. In the resulting declaration, member states avoided very much to define the rule of law principle at the international level, as well as using language implying that the rule of law is a binding principle of international law, and dedicated themselves to support efforts to uphold the sovereign equality of all states, to respect their territorial integrity and political independence. In the subsequent rule of law debates in the 6th Committee of the UN General Assembly, some light was shed into understanding how states perceive the international rule of law and its core requirements. For instance, cases such as the ICJ case or judgment on the Colombian-Peruvian asylum case was quoted, studying the attitude of states before this principle, or in the the ICJ case on the Electronica Secula case, when doing some considerations concerning predictability and consistency. In the 6th Committee also, but in CELAC or the ASEAN, much emphasis has been put on the predictability of rules of the international law as an element of this principle. Therefore, at least in these forums, no less than 117 states have expressed the view that predictability or certainty are elements of the international rule of law. Concern principles, it hasn't been clarified. All statements point to the importance of consistency in the application of legal rules for the international rule of law. Double standards and claims of exceptionalism in the application of international law have been described as unacceptable and as promoting politicization of the law. Instead, a number of states have called for fairness and equality in international law. In this context, the ASEAN and the African Group have described consistency as an element of the international rule of law. Also, the continental shelf case opposing Libya and Malta, the court, the ICJ, found that the justice of which equity is an emanation is not abstract justice, but justice according to the rule of law. The requirements of consistency and a degree of predictability are not deduced from abstract justice, but from a rule of law in international law. In contemporary academic literature, the rule of law has been described as the raison d'être of international law and as the single most important goal of the international system. But as Collins has put it, how are we to understand this recurrent reaffirmation of the rule of law ideal given the constant frustration over its realization in practice? Christopher May has recently defended the idea of the rule of law as a kind of global common sense, which functions as such only because a certain indeterminacy as to its core meaning exists. Given that international law is a socially constructed form of institutional practice, to dismiss the relevance of the international rule of law would seem to undermine the coherence of this practice as it is understood by international legal participants themselves, a group which include states, international lawyers, international organizations, and other relevant actors, why not national societies of or for international law as well. One still faces a further difficulty in giving a plausible account of the international rule of law. This difficulty comes from the simple fact that the question of what is important or valuable about international law is itself a matter about which the modern discipline appears fundamentally conflicted, revealing opposed understandings of the role and function of legal rules in the conduct of international politics. From amongst these many understandings, there emerge two plausible, convincing idealizations of an international rule of law. A more rationalist, functional or instrumental understanding on the one side, a more formal, procedural and fundamentally pluralist understanding on the other. We might say that the international rule of law is an ideal that is intrinsic to the systemic integrity of international law as a decentralized legal order. It subsists in the idea of legal association between political actors related to each other formally, rather than because of shared values or ends. Accordingly, frustration over the realization of the rule of law, the story of hope and frustration, skepticism and disenchantment appears. Insofar as international lawyers increasingly grapple with the problem of the accountability of global governance, institutions, and the rule of law features as an important critical counterpoint in coming to terms with this phenomenon. For as long as international law has been thought of as a broadly consensual institutional practice, its core doctrines, sovereignty, self-determination, statehood, sources, etc., assume something like the rule of law as the basis of mediating the individual sovereignty of states. As such, the rule of law has entered international legal imagination as a necessary presumption of the very idea of international law, the very idea as an institutional practice, the legitimacy of which is related to the self-authorship, non-arbitrariness, and autonomy or objectivity of international legal rules. However, insofar as this understanding has always seemed somewhat problematic when applied at the international level, where the decentralized institutional structure of international law seems to undermine its autonomy and objectivity in practice, the rule of law emerges also as an equally important reformist ideal, stressing the important work to be done to complete such a vision of ordered international relations. According to what has been said, First, the rule of law is inescapably important to the coherence of modern international law, both as an idea that structures international legal practices and normative expectations, and as an ideal in the self-understanding of international law as a kind of collective project. Second, the concept of the rule of law, as it has developed in the domestic context, cannot easily be translated to the international legal order due to the structural differences perceived and somehow justified in the unique circumstances of international relations. The rule of law functions as the basis of association in international relations. On these terms, it represents a more substantive commitment to legality as a counterfactual abstraction of the international legal relationship, an ethos of playing by the rules. The point is deeper than, in words of Collins, the point is deeper than that the sovereign states of the international order find themselves always entangled in international law as they consider how best to advance their interests. It is that they are themselves creatures of international law, and to maintain their status as sovereign states, they must treat as binding the law that constitutes the jurat community of which they are a part. Hence, when one state raises a question about the legality of another's action or proposed action, that state must accept the onus of justifying its action as having a warrant in a reasonable interpretation of the law. The rule of law represents an ideal expression of a shared moral commitment to a system of common rules, the authority of which stems from its commitment alone and not from any sense of higher purpose or instrumental benefit. The rule of law is also an institutional ideal, we have said, the emergence of a global governance. The brief account of the international rule of law, this brief account of international rule of law reflects the collective experience of the modern discipline in trying to work out a feasible and legitimate system of positive laws as a means of structuring international political relations.
Thank you, Professor Ana Salina de Frias. We appreciate your reflections, the overview you have provided us on the ideal of the international rule of law. Thank you so much. We are now honored to have Professor Aiko Nakai. She's Associate Professor of the Osaka Metropolitan University and member of the Japanese Society of International Law. We really appreciate her making the trip all the long way here to Peru. So please, Professor Nakai, the floor is yours.
Thank you very much. Buenas tardes, damas y caballeros. Soy Aiko Nakai de la Universidad Metropolitana de Osaka de Japón. Soy miembro de la Comité de Relaciones Internacionales de la Sociedad Japonesa de Derecho Internacional. Ante todo, quisiera agradecer a la Sociedad Peruana Gracias. Sociedad Peruana de Derecho Internacional, que ha organizado este evento y que ha invitado a nosotros. Bueno, mi español termina aquí. Ensuite, je voudrais exprimer également ma haute considération à la Société française de droit international pour le droit international, qui a organisé la première et la deuxième réunion. Et je souhaite que l'échange international entre les juristes de différentes nations continue toujours avec succès. And now I will switch my language into English so as to start my presentation. The title of my presentation is Dialogue Between Jurisdictions, Rule of Judges in Global Governance. The aim of presentation is to discuss the possibility of judicial dialogue as a key to better global legal governance. What is judicial dialogue? This is a dialogue between judges via cross-references in their judgment. Thank you for technicians. And where am I? Okay. And what is judicial dialogue? This is a dialogue between judges via cross-references in their judgment. Please be sure that I'm not talking about a meeting of judges or their oral conversations, but I'm talking about the cross-references made in their judgment. The judges of the court of the world do sometimes refer to the judgment of other court and thus having conversation. And nowadays, many of internationalists discuss rule of law on a global scale, just a previous presenter did, but the terminology differ. Some talk about global constitutionalism, some argue world law, and some talk about global legal governance, etc., etc. But all of these arguments must face unique question. Is it possible in the situation of legal pluralism? Well, legal pluralism has several meanings, but I adopt the simplest definition. Legal pluralism here means the situation of coexistence of two or more legal orders. Therefore, here, in this sense, legal pluralism is not a matter of qualification or matter of opinion, but mere a matter of fact. Suppose there are 4 treaties, Treaty A to D. Each treaty has its own legalities, and some treaties have their own court with its own jurisdiction, and thus constituting distinct legal orders. But the domain covered by treaties, in reality, overlap. Therefore, in the overlapped sphere, the judges inevitably deal with the cases where more than 2 norms from different legal orders can apply. And the same can be said for the relation between international law and internal law, domestic law. Every state constitutes a distinct legal order with their domestic legal system, but domain overlap. And the question is how the judges react to this situation. In the past, many internationalists worried about fragmentation, saying that the proliferation of international courts may produce the greater number of judgments which are not compatible with each other, and thus lead to fragmentation. But according to recent researches, there are instead interaction between jurisdictions transcending the borders, because judges of international courts, as well as domestic courts, refer to the judgment of the courts of different legal orders when they think adequate to find a harmonized solution. So now we see rather harmony among legal orders than fragmentation. And the role of judges is a new research object in international law and international relations studies nowadays. And in this context, recently we published in Japan a book entitled Judicial Dialogue, Cooperation and Competition Among Courts and Tribunals. Unfortunately, this book is in Japanese. I cannot show you that on the cover of the book, yes, we see the English version of the title. And I have important information for you. These 4 ideograms mean my name. And in this book, we analyzed the phenomena of judicial dialogue from various points of view. But the main achievement is the comparative study of regional development of judicial dialogue. In Europe and America, the remarkable characteristic of the judicial dialogue in this region is the supranational region international law and domestic law. The intensified judicial dialogue between the 2 legal orders are very specific in this region. And what is also remarkable is that there are institutionalized judicial dialogues, as well as spontaneous ones, between international and domestic courts, and between international courts, and also between domestic courts of the same region and of different regions. So the judicial dialogue now is not only transnational, but also transregional. When it comes to Asia, we don't have yet a remarkable institutionalized judicial dialogue, but we do have some spontaneous dialogue between domestic courts. Judges do make reference to international law or to foreign domestic law in domestic judgments if they found adequate. And as a matter of fact, more and more courts give weight to comparative law. Some of them established a research center for comparative law recently. So for the moment, we can partially conclude that judicial dialogues are playing a positive role towards a better global legal governance. However, we must not neglect the downsides, shortcomings. First, judicial dialogues only sometimes lead to the harmony or convergence of judgment. Sometimes judges don't agree and battles of judges happen instead of the harmony. And second, the values, when it comes to the values such as democracy, rule of law, or constitutionalism, which are the parameters of good governance, they have been assured at the national level traditionally, and they are still being assured at the national level. Therefore, the intrusion from outside via judicial dialogue is not always justifiable. There is a risk of deterioration. So at my point of view, what is important is to continue to look at carefully the consequences of the judicial dialogue all over the world from various perspectives, including critical perspective. This concludes my presentation. Thank you very much.
Thank you very much, Professor Aiko Nakai, for your very, very interesting presentation, and you certainly highlighted this a bit strange phenomena by which, despite the weakness of the institutional mechanisms, there's significant judicial dialogue among these, or within this spaghetti bowl of different jurisdictional mechanisms that have been established worldwide, and there's certainly much room for discussion. The amazing thing is that I mean, there's always certain dissonance between these different jurisdictional mechanisms, but in general, the dialogue is working despite these the institutional weaknesses in that regard. So thank you so much. We now have the Professor Pablo Martín Rodríguez. He's Professor of International Law and European Law at the University of Granada in Spain. He will talk about the rule of law in Europe's regional peculiarities. So, adelante, profesor Pablo Martín Rodríguez. Adelante, por favor.
Hola, buenos días. No sé si se me escucha bien.
Perfectamente.
Thank you very much. Good morning, everyone. Bonjour à tous. I would like, first of all, to thank the organizers of this third world meeting of international law societies, and in particular our host, Peruvian Society for International Law, for having invited me to take part in this major event. I also would like to tell you how sorry I am. I haven't been able to make it and to be physically present there in Lima. I would have loved it, but sadly I couldn't. So thank you also for letting me address you in this way online. As said by the chair, I am going to talk about certain regional peculiarities of the rule of law in Europe, mostly in the European Union. And the first thing I would like to say, I will try to keep my speech under 15 minutes, as I've been told, is that I'm not I don't want to talk about international rule of law, which as Professor Salina has taught us is quite a complex issue, but about the rule of law as a condition to be met by states. I think that in international law we can find certain rules that are connected to the rule of law as a notion, but I think that this is a sort of a fragmentary recognition. Therefore, I think that lacking this general binding definition, or this binding definition on general international law, the rule of law becomes a legitimacy condition applied in international settings, such as international organization and such. So we need this kind of legal basis either in the treaty or in an institutional international legal act. In this sense, the European Union has a robust treaty foundation. Article 2 of the Treaty of the European Union said that it's as follows: the Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. These values are common to the member state in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. So we have this robust or firm treaty foundation. But I think, and here comes probably the first peculiarity, is that I think we can find a European consensus on the rule of law, which is some sort of version in between traditional approaches to the rule of law. We know that there are so-called thin version, which are approaches mostly based on formal components, and also thick versions, which are more in focus on substantive matters such as democracy and also fundamental rights. I think that in the European Union we have some sort of a thickened version, which has formal components but understood in the light of other components. Also to the point that we have for the first time, I think, a binding legal definition in Article 2 of regulation on the general regime of financial conditionality for the protection of the EU budget. If you see, this is a good example of the thickened version, because it said that the rule of law includes the principle of legality, implying a transparent, accountable, democratic, and pluralistic lawmaking process, legal certainty, prohibition of arbitrariness of the executive powers, effective judicial protection, including access to justice by independent and impartial courts, separation of powers, and non-discrimination and equality before the law. The rule of law shall be understood having regard to the other union values and principles enshrined in Article 2, as mentioned. So we have this firm condition, but we also, I think that this legitimacy condition entails, at least in the European Union, 3 dimensions. It's a condition for legitimate membership because it's an accession requirement as provided for in Article 49 of the Treaty of the European Union. But here comes probably a second peculiarity. It's a condition for legitimate functioning of the European Union. In order to grant compatibility of the European Union legal order with the constitutional settings, the constitutional legal system of the member states, it has to be translated this notion to the EU itself. And in this operation, this translation, which is a quite, in my opinion, a sophisticated legal operation, respect by the member state when applying EU law is crucial to this respect. And finally, it's also a condition for legitimate permanence. I mean, what to do, what can we do when a member state is reluctant or is violating this notion, the rule of law? Because here it emerges the dimension of expulsion or enforcement as such. And here we can say that Article 7 of the Treaty of the European Union is not, is only a political sanctioning mechanism which may end up in suspending certain member state rights, but a member state cannot be expelled from the European Union for violating the rule of law. It's different in other European institutions, as we know as the Council of Europe. So I think that what has made emerge these peculiarities is that two conventional assumptions have proved wrong later. This assumption is that once a state is part of the EU, it's going to be an increasingly better compliance with the rule, or membership would prevent involutions. Having this proved wrong, I think that we have to be aware that the third dimension, the dimension of the rule of law as a legitimate condition for permanence, i.e. the enforcement of the value, has pointed up as the main issue. And I think that here we can just admit that the political mechanism that Article 7 I mentioned before has been spectacularly failed. It has been a failure. So it has made emerge the third peculiarity, which is the judicial defense of the rule of law. And in this defense, I think that the main legal problem or legal issue, legal concern, is the competence gap. Because the EU needs to control the respect of the rule of law even beyond the scope of EU law. And this is quite a complex, I think, issue and endeavor. So, however, the Court of Justice, the Luxembourg Court, has embarked on this jurisdictional defense, and apart from some question in judicial cooperation in criminal matters, sorry? Oh, I thought you were talking to me. It has reinforced the rule of law in this three dimension I mentioned before, as an accession requirement, because the court has said that there is in EU law a principle of non-regression, which means that once the state is part of the European Union, it cannot reduce the level of protection of the value. Also, as a legitimacy condition for functioning, because the court has said that respecting the rule of law is a condition for the enjoyment of all the rights deriving from the treaties to the member states, but also as a legitimacy condition or condition for legitimate permanence, because the court has admitted that the EU has or possesses implied competence to defend the rule of law to the full extent of its power, within the limits of its power. And in this regard, the court, which has done, in my opinion, is to reinforce the binding nature of the value of the rule of law. It has done that by connecting the rule of law to other pieces of EU law, holding or saying that these rules give concrete expression to the notion of the rule of law, and so on, and so it can have binding nature, direct effect, etc. It has happened with general principles of EU law, also in some particular mechanism, which is the cooperation and verification mechanism regarding Romania and Bulgaria, and particularly with this article, Article 19 of the Treaty of the European Union, in which the court has stated that this is a rule regarding effective judicial protection, which gives concrete expression to the rule of law and has not only direct effect and a binding nature, but it has an larger scope, not requiring an actual application of EU law. It has also done that with admitting or assuming the validity of this financial conditionality regulation, and it's still pending. This case I mentioned here, Commission v. Hungary, it's still pending, but in this case, the court is being asked to rule on whether Article 2 may be autonomously applied. That is, if Article 2 is binding by itself. We will see what the court will say. Sorry. Of course, this judicial defense hasn't come without a price, I think. I just mentioned here three of the risks I think that it implies, this answer, this response, judicial defense implies, which are probably the first one is more of a technical nature, because this case law is quite problematic, and we can even say that it's not fully consistent with other parts of the EU court case law. The second one is more of a legal policy nature, because this case law has provoked clear constitutional resistances, especially by certain constitutional courts like in Poland, Hungary, and Romania. And the third one is more of an institutional problem, in my opinion, or a risk, because even if we are talking about the rule of law, and this means a lot about judges and courts and tribunals, I think, in my opinion, there has to be a defense of the rule of law beyond the jurisdictional realm. So, summing this up, which are these specific European features regarding the rule of law? In my opinion, they are these four. The first one is this European consensus on the rule of law, to the point of having a binding, legally binding definition on a thickened version, which is formal components understood in a substantive manner. The second one is the application of this notion to the European Union itself, and not only to the member state, which is a quite complex and interesting thing. And I would recall that the intervention or the presentation of Professor Salinas before, how difficult it is to apply this notion to the international legal setting, to an international legal setting. The third one is the reinforcement of this notion by making it to encompass several legal obligations. We are not dependent on an actual application of EU law, which is quite interesting. We can see that in this non-regression principle in Article 19 and another. But finally, I think that this jurisdictional defense may point to a fourth specific European feature, which is that this jurisdictional protection is on the value itself. And I think in different international, in other international settings, we can find some sort of protection of the rule of law, but it's, in my opinion, mostly individual rights connecting with the rule of law, but not the rule of law itself. So I think these four may imply or may point to these specific European peculiarities. And I just thank you for your attention, and I give the floor to the chair. Thank you very much.
Thank you so much, Professor Pablo Martín Rodriguez, for this very substantive reflection on the contribution of European law to the notion and the ideals of the global rule of law amid the peculiarities and complexities of the European legal systems. We now have Professor Shinji Sawada. He's a professor at the National Defense Academy of Japan. He will reflect on the international law for deepening democracy. We really appreciate his contribution and his effort to come into Peru all the way from the home. Thank you so much. Please, the floor is yours.
Estimados participantes en esta mesa redonda plenaria, encantado de conocerlos. Muy buenos días. En primer lugar, quisiera agradecerles la invitación al tercero Congreso Mundial de la Sociedad de Derecho Internacional. También quisiera agradecer a la Sociedad Peruana de Derecho Internacional por haber organizado la mesa redonda plenaria, Derecho Internacional, Democracia y Gobernabilidad. Ok, voy a cambiar a inglés. Sorry. In general, international law does not require any particular political system or ideology, whether domestically democratic or authoritarian. In addition, international law has prohibited interference in the internal affairs of other states. However, since the 1990s, there has been an increase in the number of claims that global governance and international law should reflect democratic values. As a reaction to this trend, in recent years, authoritarian states have been increased on the rise. Today, I would like to consider global attempts by the United Nations and efforts by regional organizations to address international law and democracy. In recent years, we have seen the terms of authoritarian state or autocratic states as the opposite meaning of democratic states. Freedom House and The Economist publish annual surveys on freedom and democracy, authoritarianism in the world. Freedom House and The Economist, another institute, the Varieties of Democracy Institute, VDEM, is an independent Swedish research institute that has recently received a lot of attention. In its annual report published this month, VDEM summarized that the level of democracy in the world in last year has returned to 1987 levels. Year 1987, under the Cold War. Regionally, Asia Pacific is at the 1978 level, and Latin America at the end of the 1980s. sorry. I'm sorry, a little bit mistake. Therefore, first, let's consider this problem historically, especially UN efforts. There are several levels. No problem. Okay, yeah. There are several official UN documents from the Cold War era that are considered the basis for UN's promotion of democracy. While the words of election and suffrage appear in the documents, but the word of democracy does not appear once. The Cold War era did not create the momentum for the UN to take positive action. So only suffrage and voting on the election, but no, there is no word of democracy. And it was not until the 1990s, after the end of Cold War, that the expression democracy began to be used in official UN documents. Two approaches to democracy by the United Nations appeared after the era of Cold War. The first approach as a creator of new international norm. The second is approach as a promoter of democratic governance. With the end of the Cold War, the United Nations political role in resolving regional conflicts became more active. In Namibia, Cambodia, El Salvador, and Mozambique, the United Nations contributed to the building of new democracies through election implementation and monitoring, constitution making, and judicial and police reform. Sorry, this one. With high regard for UN activities, Secretary General Boutros Ghali attempted to publish an agenda for democracy. However, opposition from some countries forced him to change the title to Agenda for Democratization. Boutros Ghali's argument was that sustainable development presupposes active political participation of citizens or democracy. In response to this, criticism from developing countries that development comes first before democracy. Then the term of democratization was chosen to mean that the will of the people should be well reflected. Secretary General Boutros Ghali's attempt unfortunately failed because the UN is composed of diversely politically oriented membership. Conflicts between two groups, pro-democracy and anti-democracy, were invisible in the 90s, but intensified in the 21st century as the number of authoritarian states increases. Since 2000, the United Nations has moved to promoter approach. This approach aims to promote democracy through freedom of political choice, protection of human rights, rule of law, strengthening accountability, election monitoring, and capacity building. This approach is realistic but requires long-term financial support and sustainable interest of member states. Disappeared. Millennium Declaration, adopted by United Nations General Assembly in 2000, was the first UN consensus document to include a section on human rights, democracy, and good governance. However, in the MDGs, Millennium Development Goals adopted at the same time, there were no specific actions. While World Summit Outcome Document 2005 finally translated Millennium Declaration into concrete action. For example, United Nations Democracy Fund was created in order to subsidize civil society organizations around the world. Today, however, promoter approach also fell into stagnation. Economic growth in authoritarian states has diffused the view that democracy is unnecessary for development. Democracy-supporting countries are now on the defensive, trying to protect the democratic achievement of the 1990s. Not much time left, but I will turn next to regional efforts to protect democracy. After the Cold War, in each region of the world, democratic clause was established in treaties, protocols, or in other instruments of regional integration organizations in order to provide a regional defense of democracy. Democratic clause is a clause that suspends concerned countries' membership in a regional organization if democracy is suspended in an unconstitutional procedure in member country. The Treaty of European Union, Article 7, and the Charter of the OAS, modified in 1992, Article 9 of the Article 9 contain provisions on democracy. Notably, the democracy clause is also set up by regional integration organizations in the so-called Global South, contributing to the defense and maintenance of democracy in the region. For example, Mercosur, soon after its establishment, Mercosur introduced the democracy clause by adopting the Ushuaia Protocol in the wake of the Paraguayan coup d'etat uprising. Subsequently, the democracy clause was invoked in the wake of President Lugo's dismissal and is still being invoked next against Venezuela. The democracy clause in Mercosur was originally introduced in anticipation of another military coup, but it has been invoked in a different situation than envisioned. And African Union also adopted a democratic clause, but I will not discuss the African Union due to time considerations. Next. ASEAN, the Association of Southeast Asia is very interesting case study. This is because the Association of Southeast Asia has traditionally strictly maintained the principle of non-interference. The democracy clause in Southeast Asia does not include the measure of suspension of membership. However, during the summit talk, Myanmar military junta has been skipped the turn of the rotating chairperson rotation. Myanmar was skipped. The adoption of such a measure by ASEAN, which is conservative with respect to national sovereignty, is a milestone. As a conclusion, democracy and democratization is always said to be from above or from below. There are limits to global activities such as the United Nations, which is required to be neutral and impartial. It can be lessons from the wisdom of regional organizations should recognize importance of from the side or horizontal dimension. Okay, thank you very much.
Thank you so much, Professor Shinji Sawada, for sharing with us this overview of how the notion of democracy has been evolving in international scenario, and particularly within international law and international organizations. We now have some very quick final thoughts by Doctora Isabel Recabarren. I will introduce her in Spanish. Ella dirige el Centro de Estudios sobre la Unión Europea y América Latina, es doctora en Derecho Internacional de la Economía, ha coordinado por 2 legislaturas el Foro Euro-Latinoamericano de la Mujer en la Asamblea Parlamentaria Euro-Latinoamericana del Parlamento Europeo, y es una académica y gran amiga de la Sociedad Peruana de Derecho Internacional. Así que Isabel, y miembro sin duda, claro que sí. Luego tomaremos muy rápidamente 3 preguntas del auditorio. We'll give room for at least 3 questions, 3 quick questions from the auditorium. Thank you so much.
Buenas tardes, soy Isabel Recabarren y invitada a participar de la parte final de este bloque, que lo considero sumamente interesante, porque habla de 3 temas que son muy importantes, sobre todo para las mujeres, porque el tema de la democracia, el tema de las libertades, prácticamente determinan nuestra vida. Entonces, yo quiero hacer un pequeño repaso en pocas líneas sobre que la democracia en realidad es la capacidad que tienen todos los ciudadanos para poder decidir y además poder saber qué cosa deciden. La democracia se opone a la tecnocracia. La democracia no es autoritarismo, no es totalitarismo, no es dictadura, no es autocracia. La buena democracia debería ser una meritocracia electiva. Liberalismo y democracia inicialmente estuvieron contrapuestos. Cuando se concebía la democracia como una sociedad igualitaria, un concepto que obviamente se contrapone al liberalismo. Si la democracia es la natural consecuencia del liberalismo, su importancia radica en haber fijado principios y derechos, como es el derecho de libertad, de asociación, de reunión, de expresión, de prensa y los derechos civiles. Lo sabemos bien las mujeres que han luchado, muchas atrás de mí, para poder tener esos derechos. También los derechos políticos, para ser parte de la toma de decisiones. Entonces, ¿cuáles son los requisitos mínimos que tiene la democracia? Según Bobbio, En democracia, las decisiones colectivas se toman por mayoría. Las reglas son establecidas por la mayoría y las decisiones son colectivas. Quienes deciden deben elegir ante condiciones reales y entre diferentes partes. Por ejemplo, lo supo bien él cuando dice el fascismo no te ofrecía alternativas. Era eso. Hasta ahora, la democracia política no se ha extendido a la sociedad como debería. No se ha convertido en democracia social, porque para convertirse en democracia social requiere de educación, requiere que haya una educación masiva. Por ejemplo, algo que hoy día en la mañana la doctora Orbegoso, que ahora lamentablemente no está, lo ha hecho presente y es el gran problema latinoamericano. Y ahí viene la acción de la sociedad civil, de la academia, de las asociaciones profesionales, de crear movimientos, de mover a las instituciones. Cuando la institución no responde a lo que verdaderamente la sociedad necesita para su mejoría, para llegar a esa democracia social. Porque sin esa democracia social tendremos siempre dificultades de tener paz social. Yo quisiera relatarles brevemente lo que fue el Foro Euro-Latinoamericano de la Mujer, que fue una iniciativa de la Academia a la Asamblea Parlamentaria Unión Europea-América Latina. La Asamblea Parlamentaria Unión Europea-América Latina nació en el año 2006 en el Parlamento Europeo, 75 parlamentarios europeos, 75 parlamentarias latinoamericanos. De un trabajo previo que se hizo muy intenso para lograr esta estructura jurídica, luego cuando se llegó a la composición, todos eran hombres, las mujeres habían desaparecido. Entonces, la pregunta legítima que nos hicimos desde la academia en Italia era, ¿dónde están las mujeres? Y no teníamos respuesta, habían evasivas, hasta que alguien tomó la buena idea de decirnos, vengan y expongan sus ideas al Parlamento reunido. Fue una oportunidad que nos dijeron 10 minutos y si no funciona, no vuelvan a preguntar nada y si funciona, para adelante. En efecto, lo hicimos y pudimos analizar que tanto la mujer europea como la mujer latinoamericana no navegaba en buenas aguas. Teníamos dificultades de tener representación política, económica, la representatividad de la mujer era mínima, escasa, y los hombres, por muy buena intención que tengan, no llegan a saber lo que verdaderamente la mujer quiere, porque la mujer es la única que sabe lo que quiere para ella. Es así como hubo gran respuesta de parte de la, en ese momento, presidenta de la Comisión Social, la señora portuguesa Edith Estrella, y el senador uruguayo, Carlos, que voy a recordar en este momento su apellido, y porque las asambleas y las comisiones son euro-latinoamericanas, un representante europeo, un representante latinoamericano. Y dijeron, hay que hacerlo. Y se animaron a hacerlo, pero lamentablemente la política no lograba coordinarse. La izquierda con la derecha no lograban. Entonces nos llaman y nos dicen, ya que ustedes lo han propuesto, coordínenlo, porque es necesario que la sociedad civil logre estar en medio como una necesidad constante para poder equilibrar las fuerzas políticas. Bueno, eso yo que dirijo el CEFIAL, acabé estando 10 años en el Parlamento Europeo trabajando para que este Foro Euro-Latinoamericano de la Mujer tuviera vida y pudiera involucrar a Europa y América Latina. El trabajo interesante fue que la decisión de la sociedad civil obligó a la señora, obligó moralmente y obligó porque era mujer, la señora Catherine Ashton, en ese momento ocupaba el cargo que actualmente tiene el señor Borrell, era representante de las relaciones externas de la Unión Europea. Cuando ella vio esa decisión de este grupo de mujeres, que eran muchas italianas, porque hasta incluso el Ministerio de Desarrollo Económico de Italia se involucró en la idea, la Municipalidad de Milán se involucró en la idea, nos financiaron para que pudiéramos trabajar porque había que hacer muchas actividades, reuniones, hemos estado en Argentina, hemos estado en todos los países de América Latina, en la comunidad andina, hemos estado en diferentes lados. Las respuestas eran, primero, de disculpas, porque en las declaraciones anteriores las mujeres estábamos colocadas en el párrafo donde se hablaba de los minusválidos, de las poblaciones minoritarias, y ahí estábamos inscritas. O sea, se ayudará a las mujeres, a los grupos minoritarios, a las personas con discapacidad, ahí estábamos. Todo lo demás eran grandes proyectos con visión masculina, no porque quisieran excluirnos, era porque la voz de la mujer no estaba, nada más. Entonces, es así como la señora Catherine Ashton pide que se cree en la Declaración Unión Europea-América Latina el plan de acción que ahora, si ustedes tienen idea cómo funciona de las relaciones Unión Europea-América Latina, seguramente lo saben, tiene una declaración política y luego un plan de acción que comprende diferentes rubros. Uno de los rubros es el capítulo de género. Y ese capítulo de género lo propuso la señora Catherine Ashton porque vio la madurez, el deseo de que la mujer tuviera una representación política. Lamentablemente, hasta ahora, yo ya desde el 19 he dejado la gestión porque entró toda una ola de izquierda en América Latina y quisieron aprovechar ese espacio para trabajar en hacer escuelas de política para las políticas. Ya no más utilizar los fondos que se daban para poder mejorar la situación empresarial de la mujer, la participación en la participación verdaderamente política. Entonces comenzaron a llegar muchas diputadas mandadas por el señor Correa, por el señor de Nicaragua, por el señor Evo Morales, a fin de que puedan prácticamente avasallar, entrar con mucha fuerza en el Foro de la Mujer y comenzar a querer cambiar las reglas. Esto obviamente paralizó. Entonces esto, ya para darles una idea que hay mucho todavía por hacer. Ahora, si esto se habla de democracia y modos de trabajar, también tenemos que tener en cuenta cómo trabaja la Unión Europea. La Unión Europea, por ejemplo, en estos días, ayer y hoy día se ha reunido en Bruselas y precisamente ha estado Antonio Guterres en esa reunión y ha hablado con los 27 países para que el apoyo a Ucrania se siga llevando adelante. La declaración del Consejo ha salido y sale en el sentido de que hay que dar un masivo apoyo a Ucrania, o sea que las instituciones no solamente declaran, también se mueven. Y Antonio Guterres ha estado en eso. Ahora, la gobernanza precisamente va también en las modificaciones. La población europea está disminuyendo, las elecciones del Parlamento van a ser el próximo año, hay 705 parlamentarios, pero son elegidos en base a la representación poblacional. Si las poblaciones están reduciéndose, hay un desequilibrio. ¿Cómo tienen que hacer? En este momento están trabajando, pero ellos tienen muy claro lo siguiente: las instituciones tienen que trabajar unidas para lograr los objetivos a favor de la Unión Europea, de los 27 países, que es la razón de ser de la Unión Europea. O sea que esta estructura supranacional, que podría decirse que es un superestado, en realidad lo único que hace es servir, que es lo menos que lamentablemente en muchos casos se ve. Para resumir, los conceptos tienen que ser claros, el conocimiento, la educación, muy dejada de lado en el Perú, tiene que ser totalmente reactivada y potenciada. La democracia política y democracia social requiere de paz social y se debe preservar la economía, si no peligra la democracia. La exigua participación de la mujer en política, ya lo hemos dicho, también tiene cosas diferentes, la participación necesaria de los hombres. Charles Michel, que actualmente es el presidente del Consejo Europeo, en el 2015 dictó un discurso pidiendo un cambio en la sociedad belga a nivel de mujeres. En 8 años, en 7 años diría yo, ha logrado la paridad en el Ejecutivo y en el Legislativo belga, cosa que estaban a 32%. Entonces esto nos hace ver otros temas. El tema de la condición de la mujer y los úteros de alquiler. Nos hacen ver situaciones donde el cambio de sexo hace que hombres transexuales compitan con mujeres en competencias deportivas. O sea que hay muchos elementos para poder trabajar. El desconocimiento de los principios básicos también ha producido cambios constitucionales en Latinoamérica, comenzando por Venezuela, por Bolivia, por Chile, que va en su segundo proyecto porque no fue aprobado. Y en el Perú hay una parte de la población y algunos congresistas que todavía insisten en el cambio de la Constitución porque quieren cambiar el sistema económico. Y la desestabilización de los países, política y económicamente, por los grandes capitales que tienen origen en la cocaína, donde norte y sur son cómplices en el cultivo, en la transformación, en el transporte, en la cada vez masivo consumo y sobre todo en el lavado de dinero. Toda una parte de la economía mundial está infectada por el dinero de la cocaína. Y América Latina, 1 kilo de cocaína cuesta $2.000. En Europa, de 80.000 euros para arriba. Puede llegar a 200.000 euros. Entonces tenemos además estructuras latinoamericanas que no proponen democracia, sino proponen liberalidad del cultivo de la hoja de coca. Petro en Colombia, Morales Arce en Bolivia, Castillo en el Perú. Actualmente hay silencio con la señora Boluarte, no lo dice, pero hay cientos de miles de hectáreas, estoy terminando, que van a hacer florecer aún más este mercado de la pasta básica de cocaína. Entonces, toda América Latina está involucrada. No solamente los que producen la hoja de coca, también están los que comercian, los que facilitan los puertos, los que facilitan las naves. Entonces, por ejemplo, la Unión Europea para nosotros es muy importante, aunque todavía el Perú no ha entendido cuánto es importante la Unión Europea. Argentina yo la admiro porque ha definido claramente, y Brasil y el Mercosur, la Unión Europea es el camino, porque de una destrucción total y de pobreza absoluta han logrado proponer un modelo democrático por el cual han logrado el bienestar. Pero ¿qué cosa sucedió? Margaret Vestager, la semana pasada, ha venido y ha hecho una reunión en Colombia para ofrecer la conectividad. La CELAC inmediatamente ha protestado por su embajador cubano y ha dicho no debe haber una reunión fuera de la CELAC. En cambio, Margaret Vestager ha ido adelante y ha hecho la reunión sin tomar en cuenta la CELAC. Esto ya nos da una luz de esperanza porque definitivamente puede desarrollarse en este continente una autarquía muy amplia y una carencia, sino desaparición de la democracia. Pregunta, ¿qué democracia puede haber ante una sociedad contaminada por delitos? Gracias.
Sí. Muchas gracias a la profesora Isabel Recabarren. Si hubiera alguna última pregunta, is there any last question you may want to ask? Otherwise, we call to the end of the session. Bueno, cerramos entonces la sesión. Muchísimas gracias y los esperamos esta tarde. We wait you this afternoon. Thank you so much.
We thank the chairman and the panelists for their presentations. We will convene again at 15 hours in this very room to begin with the third round table. Likewise, we invite you to the courtesy lunch hosted by the UPC